Good morning. Welcome to our science seminar this week. I want to remind you next week's science seminar is entitled From Rocket Fuel to the Military Industrial Complex, The Life of the Chemist in 3 Apps. So that'll be next week, same time, same channel, right here, and very auditorium P101. Today, though, we have with us a good friend of LeTourneau University, okay, who's been here before, who's worked for LeTourneau before on intellectual property. We have with us Mr. Parker. Mr. Parker has his degree in mechanical engineering from UT Austin, okay? And he also has a law degree from Texas Tech, and he practices patent law. And what's interesting is all patent attorneys must have a degree in the sciences or engineering to become patent attorneys. Yes? So when you think attorneys, you think, oh, they were probably poli-sci majors, or history majors, or pottery majors, or something like that in their undergrad days. But no, some attorneys actually have science and engineering background. And those are the attorneys that can go into patent law. So Greg Parker is going to talk to you today a little bit about patent law. If you're interested in hearing more, we're having lunch with Mr. Parker in the Joyce Room of the Corner Cafe after the seminar, so if you want to join us there for more questions. Otherwise, let's give Mr. Parker a big
Thank you very much. Can you all hear me in the back? Yes. All good? Okay. Let me, by show of hands, who all here is either a science or engineering major? Virtually everybody, I assume. Good. So this is particularly important or wonderful knowledge for you all being in the science and engineering, having those sorts of degrees. What we're going to talk about today is intellectual property, and this is just a brief overview. I've been practicing intellectual property for 20 years now. As Professor said, I 20 years ago graduated from the University of Texas at Austin with a mechanical engineering degree. At the time I graduated, I wasn't sure I wanted to be a sit behind a desk engineer. Wasn't sure what I wanted to do. Had a good friend, his father was an attorney, and said, listen, Greg, you ought to check into being either a patent agent or a patent attorney. So I kind of followed his advice, went to law school, 3 years of law school. While I was in law school, took what's called the patent bar. And the patent bar is a separate exam that you take if you want to be a patent agent or a patent attorney. The difference between a patent agent and a patent attorney is patent attorney also has a law degree. Patent agent only has the science or engineering degree. And as Professor said, you cannot become a patent agent or patent attorney without that science or engineering degree. It's necessary to become a patent agent because it's necessary to understand the arts and the sciences that you'll be dealing with on a day-by-day basis. Again, I have a mechanical engineering degree, so I focus a lot of my engineering and law work on mechanical or light electrical or light chemical type technologies. But if you're an electrical engineer or computer science or whatever it might be, you'd be focusing on a little different technologies. Our firm, as he said, is located in Dallas, Texas. We're 11 attorneys. We have physics majors, electrical engineers, computer science, chemist, chemical engineer, mechanical engineer, and some biotech. So we can cover basically all sorts of, all the different genres of patents that may come up across all the different technologies. But anyways, to start, just real quick, make sure this is working. Oh, push on. See if that's working now. Well, I think we lost the pointer.
Oh, that's too bad. Did we get switched off again? Oh, there's on again.
Yeah, is it changing? Yeah, I can just use.
Okay. Yeah,
I'll use this as the pointer and the keyboard as necessary. You know what? The keyboard's not working. I wonder if we need to.
Keyboard's not working either. Well, that is a strange occurrence, huh? Huh. Let's try on.
See if the Wheel. The wheel's working.
Wheels working. Great.
Wheel's working. All right, just real quick, you know, sitting here today, this is just an overview of intellectual property law. If you come up to me afterwards asking questions, happy to answer those questions, but it's not legal advice at the time. Just a little, have to give that little tidbit. Intellectual property, it's basically broken into 5 types. We have the patents, which we'll spend a lot of the time this afternoon or this morning talking about. You have trademarks and service marks, copyrights, trade secrets, and trade dress. Won't spend much time on the trade dress. It's pretty. So with regard to patents, there are mainly 3 main code sections. So we'll talk about 35 U.S.C. Section 101, Section 102, and Section 103. Section 102, as you see on the screen, is basically the overarching rule that one must overcome to become patentable. So it is 35 U.S.C. 101 requires that it be new, useful, and non-obvious. Okay? It protects machines, processes, or methods of articles of manufacture, compositions of matter, and software. And so, much like you all are young enough maybe that you don't own real property, like a home or something like that, but your parents' home, grandparents' home, whatever it might be, when you own a home, it is considered real property. And so how does one ascertain what you own? Well, there are metes and bounds of your home. Typically, if you live in Dallas, where I do, it's a rectangular lot. You can go to the front of the lot, you can go to the back of the lot, and you can find basically either 4 posts or etchings in the concrete. And if you connect each one of those 4 posts on a rectangular shaped lot, everything inside of it is yours, everything outside of it is someone else's. Patents are much the same. We use words, not the posts, not the etchings in the concrete, but we use words in a patent to describe what you own as opposed to what someone else might own. And patents, you have a term of 20 years. So essentially the United States Patent and Trademark Office is willing to give you a 20-year monopoly on that technology, assuming you get the patent. So long as you'll disclose it, you'll make it public. And the theory goes that if you disclose it and make it public, others in the industry can build upon that, and it just brings about innovation. So what are a patentee's rights? A patent gives the owner the right to exclude others from making, using, selling, offering to sell, or importing into the United States a patented invention. That's really important. One thing that many people overlook is a patent does not give you the right to do something, but it gives you the right to prevent others from doing something. Okay? So here's an example. Inventor A invents a bicycle without brakes, and inventor B invents a brake for a bicycle. So one has the patent on the bike, one has the patent on the brake. Okay? But neither the person that owns the patent on the bike, he or she can't manufacture a bike with a brake because the brake is owned by someone else. Similarly, the guy who has the patent, or the whoever it might be who has the patent on the brake, couldn't build a bike with a brake as someone else owns the patent on the bike. Does that make sense? So again, that goes to the difference between the right to exclude others, which a patent grants you, and the right to do it yourself. So neither one of these can make a bicycle with the brake without the other's permission, even though each of them has a patent. When should you file a patent? So you should file a patent as soon as you can. If you have an idea and you want it protected, you should file that as soon as you can. You know, the United States has a 1-year grace period they'll allow you to disclose to someone else outside of your family or otherwise make it public, and you're still entitled to a patent. A lot of foreign jurisdictions do not allow that 1-year grace period. So, for example, if you go send it off to Amazon, maybe try and sell it on Amazon. If you don't have your patent application on file prior to that, you are not entitled to a patent in foreign jurisdictions. Again, the United States has that 1-year provision. It's just a grace period. The United States understands that filing for patents can be fairly expensive, actually quite expensive. And a lot of times individuals, small companies, they would like to go out, manufacture it, sell it, maybe make some money so that they can pay for the patent process. So that is one of the things that you should do is, if at all possible, get your patent on file before disclosing it to the public. You do have that 1-year grace period. However, in 2011, the United States patent laws changed from a first to invent to a first to file. So nowadays, where before, if I invented something back in, say, 2000, we'll act like it was before 2011. So in 2009, I invented something. You've probably heard the stories of where someone will write what they invented on paper, they'll put a stamp on it, put it in an envelope, put a stamp on it, and mail it back to themselves and never open it. So they've got this. The United States Postal Service has stamped it as delivered on December 1st, 2009. And you could rely upon that as the date when you, at least as early as the date when you conceived of whatever is in that package. Say, for example, you didn't have a chance, didn't have the money, didn't have the time to file a patent application. And in 2010, someone else comes along and files a patent application on exactly your idea. Wow, they beat you to the punch. No. Before this September 16th, 2011, you could go predate them. You could say, hey, you weren't the first to invent. I was the first to invent. Here's my envelope. Here's my, notebook, engineering notebook that's signed by myself and a witness, whatever, and you could predate them. But as of September 16th, 2011, the rule is first to file. So you lose that benefit of the first to invent, and that is another reason why you would want to get your patent application on file before someone else hears about it, because they may file upon that. There are mechanisms you can do to invalidate that, because they didn't invent it. They took your idea and filed upon it, but it's a costly process and something that you wouldn't want to do. So in general, if you have the time, you have the money, it's best to file a patent on your idea prior to disclosing it to the public. How do you protect before filing? You can keep it secret. Like I said, don't tell anyone. You can tell your close family. I wouldn't let it go outside family. Because the question is, what is a public disclosure? There's no real rule for what is a public disclosure. One would argue that your siblings, your parents, your spouse wouldn't be a true public disclosure. One might argue that, hey, your best friend wouldn't be a public disclosure, but those that are trying to invalidate your patent down the road, if they know about it, they're going to take the separate, make a separate argument there. So again, how can you protect before filing? You can have the person or company to whom the idea is being shown sign a non-disclosure agreement. If they sign a non-disclosure agreement, which you can hop online and find sample non-disclosure agreements just anywhere. I would suggest if you're wanting to disclose it to someone who's manufacturing it, if you don't have the time or money to get the patent on file before doing so, you have them sign one of these non-disclosure agreements. So, the inventor can also promptly make a careful written description with as much detail you can have, including drawings, and have it witnessed by someone under a non-disclosure agreement. That helps get that date down. Or you can file a provisional patent application. A provisional patent application is a very simple document. Could even be your engineering drawings. It could be your pages from your engineering notebook. And you get that on file with the Patent and Trademark Office. The difference between a standard patent and a provisional patent is that it doesn't need to have all the detail. It doesn't have the claims. Remember I said that words define what you own. It doesn't have those words at the end of the patent that will detail what you're trying to own and claim. And therefore, it's much less expensive to file. A lot of times, rather than using a patent agent or a patent attorney, if you have a very detailed write-up, you can file that with the Patent and Trademark Office. And depending, the filing fee with the Patent and Trademark Office may be $100 or less. What does that provisional do? That provisional basically buys you it buys you a year in which to convert it from the provisional to the non-provisional. So again, if you don't have the time, money, energy, whatever it might be, it buys you 1 year of time in which you can go out there, disclose it to the public, you can sell it, try and bring in some income, at which time you have to convert it after 1 year. Again, one of the key, a lot of people in the past, many years ago, they would just file a drawing as their provisional patent application. And these days, that's not sufficient. You need to have some write-up walking you through what the drawing entails, how it might work. Just as much detail as you can provide is best. Again, like I said earlier, the more detail, the better. In theory, a provisional should contain as much detail as the non-provisional contains. It's never the case that it's 100%, but the majority or the important facts should be contained within that provisional application. You get, when you file a provisional, say I filed a provisional today, what is it, November 8th, 2019, and I'm going to have to convert that on November 8th, 2020. I will have a filing date through the entire document of November 8th, 2019. Again, I said that you had that 20-year monopoly where you are the only one. You can exclude others from making, using, selling, offering for sale, and so on and so forth for 20 years. That goes from your earliest effective filing date. So if you file your provisional patent application on today, you would have until November 8th, 2039, if I'm doing the math correctly. So that's what we're talking about here, where it provides the means to establish an early effective filing date right here. All right. So who is a provisional patent application suited for? Individuals, small companies, those that can't afford. I'll give you the average price for getting a non-provisional, so a full patent application on file in the United States, just to get it on file, is somewhere in the $9,000 to $11,000 range. Again, that is money that would be paid up front at the filing of the patent application. And then, you know, as I'll talk about later on, it takes a while for you to negotiate with the Patent and Trademark Office and so on and so forth. So the provisional really has a place and can be very useful. Unfortunately, it can be abused. You know, you'll file a patent application, a provisional patent application, a lot of people will, and then they'll sit on it for 11 months and 20 days, and then get a call from, you know, it'll show up on their calendar, or get a call from a patent agent or a patent attorney saying, we've got to convert this. And it's just a rush job to get it done in those last 10 days. A provisional should be used as a placeholder to allow you over the next 2 to 4 to 6 months to really develop the idea and decide whether you're going to move forward with it or not. So, how much does it cost? As I said, somewhere in the $8,000 to $12,000 range. Depends on the technology. Computer software stuff, more expensive. Mechanical, if it's very simple mechanical, on the lower end of that range. And again, that does not include the costs associated with the prosecution of the patent application. So again, when you file a patent, you file it with the Patent and Trademark Office. They're backlogged. They will sit on that, do nothing with regard to that patent application for 24 to 48 months. Again, it depends on the technology group that will be examining it, and just how busy they are. But once you do get it's called an office action. The Patent and Trademark Office will give you a report saying, here's why you are or aren't entitled to a patent. 95 times out of 100, most every time, very rarely will you get them come back and say, Mr. Parker, great idea. Here's your patent. That's not their job. Their job is to push back on you and see whether you can convince them whether it's a patentable idea. And so typically you'll negotiate back and forth with the Patent and Trademark Office 2 to 4 times before either they've convinced me as their attorney that it's not patentable, or I've convinced the Patent and Trademark Office that it is. You know, there have been times, and you know, we can go on down. So again, from 3 to 5 years from the filing date before they pick it up or it may issue, I've worked on patents for 10 years or longer. I'm 20 years into my career, had a patent, you know, first month of beginning as a patent attorney, and 10 years later was when I just finally closed the book on that patent. That was for a large company who spent many tens, if not $100,000 trying to obtain that patent. But it can go a long time. So again, as I talk about, you know, day one you file the application, I said from 24 to 48 months before they pick it up. This says 18 to 36. It's a long time. It's a long time for which you can be developing the idea, you can be disclosing it to others. You are entirely protected when you file that patent application. So if you file the provisional, you're protected for what is in that provisional document. If you filed a non-provisional, you're protected for what's in that non-provisional document. And so, you shouldn't have to worry there. But as it says here, you file it. The Patent and Trademark Office will send out an office action. You will send in a response to that office action, and you may do that, 2 to 5 times before one of the things happens where it is allowed. That's where it goes from a patent application to an issued patent. You appeal it. You can go up above the examiner to an appeal board, and even up above that to a federal judge. You can refile it and recast it in a new light. Or you can, if you found out that you just believe that it's not worth your time, energy, or money, you can let it go abandoned at that stage. What are the benefits of patent ownership? So what can you do with the patent? You can license the patent to obtain a revenue stream. So again, you have the right to exclude others from doing these things. If someone wants to do it, they may come to you and pay you for that. You can litigate it to obtain substantial damages. The Eastern District of Texas, right here where we are, Longview, Marshall, Tyler, is the #1 patent litigation docket in the country. More patent lawsuits are filed here than most any other jurisdiction in the United States. Why is that? The patent holders tend to, when they bring a lawsuit here, sue large companies, and the jury pool here is very favorable on patents. When you get a patent from the United States Patent and Trademark Office, there is a presumption. The federal government stamped it saying, you have a patent, you are right. And here in the Eastern District, the jury pool is sympathetic to that, saying, hey, the government wouldn't have given this person this patent if it wasn't a patentable idea. So we're just going to go ahead and decide that it's a patentable idea. And then they look at it, they're like, okay, here's a very small company that's going up against Apple. Apple's been known to steal stuff from people, and yeah, they probably have stolen this idea as well. And likewise, the damages can be very high. So for that reason, this is a very patent-friendly jurisdiction here in the Eastern District of Texas. The companies like all the large companies in the world, the Apples, the Samsungs, any of those, absolutely hate being sued here in the Eastern District of Texas. And again, that's basically, it's the hot spot of Tyler, Marshall, and Longview. So, but beyond litigation, you can just say, hey, I'm not going to license it, and I'm not going to let anyone do this. I am going to do this myself. I'm going to build a company around this, and I'll be the sole supplier of X widget. Okay, disadvantages of patent ownership. So enforcing the patent. It's one thing to spend the $10,000 to obtain the patent, and another to get it on file, another 10 or 15 to prosecute it through. Once you have that patent, it's worthless unless you're willing to enforce it. And the problem with that is that it costs many millions of dollars to enforce patents. There are mechanisms by which that you can get around that. You can find a patent law firm that might do it on a contingency, much like you see the car wreck attorneys. It's a different scale because these are incredibly bright attorneys, but because the damages are so high, they're willing to pay for work for free in the hopes of getting a percentage of the return. That said, you can't enforce it until it issues. So again, a patent application cannot be enforced. Only an issued patent can. And only can you obtain damages from when you have advised the potential infringer that they are infringing. How can you advise the infringer that they're infringing? You can call them up, send them a letter, say, hey, here is my patent, here's my patent number. 2, you can mark on the product. If it's something that can be marked upon, you put patented and give the patent number. After that September 11th, they have a mechanism by which you can put it on a website. So if you're a company and you have a website, you can have a link to patents, and you can put the patent numbers on your website, and that gives them effective notice, not actual notice, because you didn't send them a letter, but that is effective notice. So the patent damages would run from that date when they have either the actual notice, which is when you let them know, or the effective notice, which is when you put patented on the product and or had it on your website. So we have utility patents and design patents. A design patent covers the general look and feel of the patent or of the article. So for example, they have design patents on the tread on tires. Design patent on your iPhone. You know, your iPhone and the little, home button on the front. It's not how that home button works. It's that it's a little circle up top, and then the general curves. And so it's a design patent you can file basically a design patent on most anything. And the scope of that design patent just depends on what are the other items out there. So difference between a design patent, we've been talking about utility patents in the past, the 20 years. Design patent, you have a 15-year term. And again, the 20-year term before for a utility patent was from when you first filed it. Design patents is when it issues. So you get 15 years from when it issues. Difference between a utility patent and a design patent is design patents are much less expensive to obtain. It doesn't require the technical degree and the time required for a utility patent, because essentially what you're doing with a design patent is you're putting all the different views, a front view, a back view, a side view, a top view, a bottom view, whatever, and you say, I am claiming this design is shown in these drawings. So because of that, it's much less expensive to obtain. On the flip side, it's much easier to enforce. Where we talked about the enforcing of a utility patent was $1.5 to $2.5 million on average in legal fees. It's much less for design patents. Again, you don't have to have all the technical experts. You don't. The trial will be much shorter, and for many other reasons. There are also plant patents. To be honest with you, I've never dealt in plant patents. Have no knowledge about how one would file nor prosecute one. But again, plant patents have a 20-year term from their earliest effective filing date, and they're just very rare. There will be specialty attorneys across the country. I bet there aren't more than 20 or 30 that would do that in the United States. So we've talked about patents. And we talked about Section 101, which is the overarching code section that you must kind of meet to have a patent. I don't know, maybe I glanced, went past these two slides before, but there are two other code sections when you're trying to determine whether a utility patent is patentable. The other one is 35 U.S.C. 102, and then there's a 35 U.S.C. 103. And 35 U.S.C. 102 is someone in the United States or in the world thought of exactly your idea. What are the odds of that? You would think not often would someone think of exactly my idea. Not only, the broad idea, but the narrower idea of that it's shaped like this and it has this special feature. It happens. It happens all the time. But that is not as common as, so that's called a 102 anticipation rejection. Patent and Trademark Office found exactly what you're trying to patent in a single document, whether it's a patent, a publication, a website, Google, as long as it links to a single document and that single document has everything that you're trying to patent. That's a 102 anticipation rejection. The more common is a 103 obviousness rejection. That's where the Patent and Trademark Office is saying, found, this person over here did 80% of what you're doing. But you added something. I recognize you added something. But the 20% you added really is quite nominal. Any engineer, any scientist would have taken that 80% that they had and come to the conclusion of, hey, let's just modify it here with this other 20%. When you do that, she, the examiner can take 2 different publications, or 3 different publications, or 5 different publications. The more publications and patents and stuff they have to throw together to come to your invention, in theory, the less obvious it is. But when they can just take two and throw them together and that's exactly your idea, they'll come back with a 103, 35 U.S.C. 103 obviousness rejection. Those are much more common, much more difficult to overcome, because what is obvious? What's obvious to one is not obvious to the other. You know, the inventor who came up with this improvement upon another device and spent 3 years in doing so and tens of thousands of dollars of doing so would argue that wasn't obvious. I had to sit there and work day in and day out to come up with this. Well, the Patent and Trademark Office, that's their job. They want to push back and say just about everything's obvious. That's why when I told you before, and I said 95 out of 100 times they'll come back and give you a rejection, it's probably 999 out of 1,000. I have very rarely had a situation where the Patent and Trademark Office comes in and says, from the very first filing, you're right. You know, I don't honestly want that. That means I didn't spread my net wide enough on what I was trying to patent. I was a little too narrow. That would be, for example, if you're trying to sell, you know, your car, and you put it for sale for $10,000 and you have 100 offers of $10,000 within the first 2 minutes. Wow, I should have asked 11,000, 12,000, whatever it might be. So we do the same with our claims and our patent and our breadth in our patent. You really don't want that so-called first office action allowance. But again, you have to overcome the 101. It has to be something patentable. A number of years back, Federal Circuit came in and said that software is not patentable. And so we've been dealing with that over the last handful of years of how do you patent software. Well, you can't patent software. It has to be tied to some sort of hardware now. There are other things, you know, a time machine. It's not patentable. Bless you. It's not patentable today because, you know, physics and it just can't happen. But again, you have to overcome 101, patentable, 102, not anticipated, and 103, obvious. So that's just a general overview of patents. Trademarks is another very common form of intellectual property. Companies that have ideas, they typically file patents and trademarks on those ideas. So the trademark will cover the name, the patent will cover the utility. So trademarks, we have federal trademarks, which is filing the trademark with the United States Patent and Trademark Office. You have common law marks. For example, you use that name in a general region of the United States. You come up with a new restaurant and it has a special name to you and you use that in Longview, Texas. Well, you'll have a common law trademark of that name in Longview. Federal trademarks gives you the right to exclude others from using that mark throughout the United States. Common law, only in your general area where you're practicing. And so then infringing trademarks. So once you have your federal or your common law mark, much like patents, once you have your issued United States patent, you can prevent others from using that. And so infringing trademarks, how do you determine if someone infringes a trademark? Is one, that it's another mark that is likely to cause confusion among consumers as to the source of goods and services. Okay? So when someone else sees you know, every time I drive out here from Dallas, there's a McDonald's deli store, I believe, sign on I-20 coming out here. And I don't understand how McDonald's has not picked the fast food chain has not picked up on that and prevented them from using that name. But the question would become, is someone driving down that highway going to see McDonald's deli and think it's the same as the arches of McDonald's? If McDonald's corporate knew about that, they would for sure try and put an end to that use, but obviously they haven't thus far. What is the process for obtaining a trademark? So much like the patent application, you file an application with the United States Patent and Trademark Office, and you will get the response, an office action from the Trademark Board. And again, their job is to push back a bit. Are you trying to get too much scope on your trademark? Are you trying to steal someone else's trademark? And so not quite as likely as you'll receive a response of no from a patent, but you'll get some sort of response in a trademark after trademark filing as well. So after you receive that office action, you file a response, And you will, just like the patents, back and forth. You negotiate how broad that trademark can be. So once it's allowed, the mark is published in the official gazette, giving owners of the mark 30 days to file an opposition, other owners. So for example, represented a client one time that manufactured kitchen equipment. And they've been manufacturing this kitchen equipment for many years, say 40 years. And they had an apple with a bite out of it stamped on one of their, let's say, a cutting board. And Apple Computer figured that out and came to them and said, listen, we think that there's likelihood of confusion of, your cutting board to our, is before iPhones, let's say, to our Mac computer. And you look at them, you just kind of say, come on, Apple, no, there's no confusion here. What do you do in the kitchen space? Do you have any cutting boards? No. But corporations like Apple have as much money as they can throw at it and essentially bought that trademark that we had for the kitchen equipment just to take it off the table of uses of an apple with a bite out of it. So someone like, if my client would have filed a trademark for that in the kitchen space, Apple would have this 30 days to file an opposition if they were to recognize that. Trademark, what is the process continued? After full discovery, including discovery depositions and trial depositions, briefs are filed. So essentially, this is the process by which one would determine whether there is that likelihood of confusion. A lawsuit would be filed. You can have the opposition as well, which the opposition is before the Patent and Trademark Office. Lawsuit would be before federal courts. But you just have to do a bunch of discovery, determine when you thought of the idea, how likely is it that someone would be confused, and experts would come in, and each party would have their own experts, and it's just an expensive process. So that is the opposition process. How much do trademarks cost? Again, we have the utility patents, $8,000 to $12,000. You have the design patents, which are much less. Trademarks are even less. I would say that the average cost is somewhere from $1,300 to $2,500 to get the trademark on file, and it tends to actually be on the lower end of that realm. And then when you negotiate back and forth with the trademark office, another $1,200. But typically that's a one-shot deal. You'll respond back once, maybe get on the phone with the examiner at the trademark office, and so again, where you're talking $20,000 for utility patents, probably less than $5,000, if not less than $3,000 for a trademark. So they have their use in technology. Not only, again, we're covering the name of your company, we're protecting the name of your product or the logo that you use with your company or product. Then, we're talking about if the oppositions and whether you want to file a trademark lawsuit, you're talking $30,000 to $80,000 to determine whether there's an infringement in trademarks, whereas it was the $1.5 to $2.5 million for patents. So when you think of trademarks, you hear the term trademark all the time. Trademark is a broad general term for both trademarks, service marks, certification marks, and collective marks. A true trademark, if you're referring to a true trademark, is covering the name associated with the sale of goods. I'll show you a couple examples in a second. A service mark, which is still under the umbrella of trademarks, is protecting services. And then the certification and collective, those are just unique different types of marks. But to give you an example, Post-it notes. They're selling goods. They're selling products. That would be a trademark. Same Coca-Cola, goods. Service mark would be FedEx. They're not giving you any goods. They're selling the service or some other consulting firm or whatever if they're giving services as opposed to goods. And then the certification mark would be like Good Housekeeping, and collective, the association would be like the Better Business Bureau. Again, both trademarks and service marks. You can have not only a word logo, just the words Coca-Cola, just spelled out, would be a word mark. Same, if you have a phrase, it's the real thing. You can get a trademark on that. But likewise, you can do a design mark or a logo mark. So rather than Coca-Cola spelled out just in the words, standard font, you can put some artistic elements to it. You can have a logo that doesn't even have Coca-Cola in it, maybe no words at all in it. So those are the different types of formats for trademarks. So there's the Coca-Cola. It's giving you an example of the design. You know, again, the word mark is just the word. Design logo is something like that. You often see the R behind words and phrases and logos. That means that it is federally registered. It's gone through the federal process to register it, as opposed to the common law that we talked about before. If you see just a TM, that means that the company decided not to file it with the federal government and is just relying on their local rights. So the example I gave you was a restaurant here in Longview. They might put a TM after the name. And then that's for trademark. If it's a service mark, it would be an SM at the end. All right, so you see, you know, Scotch tape, there's the R behind it. That it means it's registered. 3M here did not register the 3M word. It's just common law. And then the same for the service mark for this DellAuctions.com, which they're providing a service. Benefits of registration. Why would you register a trademark as opposed to a federal trademark as opposed to have the common law? Well, it gives you the nationwide right to exclusive use. Going back to patents. Patents give you the right to prevent others from doing things. Trademark give you the right to do that. You have the right, the exclusive right in the United States, if you have a federal trademark, to use that logo, that name, whatever it might be. Why else might you register it? It shows that you own the mark. And then after 5 years after 5 years of having your federal trademark, people can't come in and say, no, I thought of that name. I used that name 10 years ago. That's my name. No, you have an incontestable status that you own that mark. And the last and probably most important, if you have a federal trademark, it allows you to use the federal courts as opposed to the state courts to bring a lawsuit. Copyrights. It's pretty simple. Anytime that you fix an expression in any tangible medium, let me say that again. It is an expression fixed in any tangible medium of expression. So once you finish the work, it has protection. So essentially, you have a copyright the moment that you write down some lyrics to a song on a piece of paper. You have a copyright on a poem that you write on a napkin at a restaurant. So when you write down some expression in a fixed medium, it can be on paper, it can be on a computer, it can be software. Software has a copyright. The code of the software, the moment that you hit I'm finished, you have a copyright on that software. So, you know, unlike the others where you have to go file for a trademark or file for a patent, no, the moment that you put that expression down, painting, any art, a song, whatever it might be, on a fixed medium, you have that copyright. Yes, you can go file those copyrights before the Copyright Office, but you don't have to. What is the duration of a copyright? It's the life of the author plus 70 years, or if it's a work for hire, so I paid you to go write some lyrics to a song, then it's 95 years from the publication or 120 years from creation, whichever is less. So what do copyrights not protect? Titles, names, individual words, short phrases, and slogans. They don't protect ideas, procedures, methods, systems, processes, and concepts, much like a patent would. Facts. So they don't protect facts, including sweat of the brow, alphabetical compilations of names in Dallas, stuff like that. Works consisting of public domain information and containing no original authorship. You know, if you're just taking other things that are already known and throw them together in a new little configuration, no, not copyrightable. So what are your rights when you have a copyright? The exclusive rights under 17 U.S.C. 106, you can reproduce it, You can prepare derivative works. A derivative work is a modification of it, so an improvement to the song, or changing up the words a little bit, or if it was a poem, modifying it a little bit. You can distribute copies of the copyrighted work. You can perform copyrighted work publicly, and as well as you can display the copyrighted work publicly. The benefits of the exclusive rights: you can prevent copying without approval, prevent distribution of your work. You can seize illegal copies. You can prevent importation of the infringing products or works, and you can prevent someone from creating a derivative of your work. So again, they can't modify your song just a little bit, can't modify your poem just a little bit. Interesting, and it may, so if you have a copyright on something, you see it right here on right here. That is the copyright of this presentation. And you use a C with a circle on it. Typically, for patents and trademarks, it is not a criminal offense to infringe someone's patent or trademark. Copyrights, there is a criminal aspect to that. You can go to jail for copying, whereas you copy someone's patent or trademark, the damages are financial in nature. But the limitations on copyrights: it does not protect ideas or facts. Someone can develop the same software code as long as they're not copying or access to copyrighted work. And then fair use. Fair use allows universities and such, allows a person to copy, display, or use portions of copyrighted works under certain conditions. So if it's for education, there are a number of them there that you can apply fair use to a copyright. Here we are. Factors used to determine fair use: the purpose and character of the use, including whether such use is in commercial nature or is for non-profit educational purposes, the nature of the copyrighted work, factual versus non-factual, what amount did you copy, and then the effect upon the potential market or the value for the copyrighted work. Touch upon trade secrets real quick. There are those situations where you don't want to disclose your idea to the Patent and Trademark Office in turn for the 20-year monopoly. You'd rather keep it internal to yourself, internal to your company. That is Coca-Cola is the perfect example of the best trade secret ever kept. How they have kept the formula for Coke from the general public and from anybody else. People have been trying to copy that for years. And so when you have a trade secret, the key is just to keep it within a very close group of people so that it doesn't get out. If it gets out, then you've lost that trade secret. Again, that is if Coca-Cola would have filed for a patent on their Coke many years ago, that term of that patent would have run and the general public could have been making exactly what Coke tastes like today in their kitchens or wherever it might be. Coke in turn decided to keep that a trade secret, and in doing so has been able to extend that 20-year term to many years beyond that. So that is the benefit of a trade secret, and it's very difficult to do. I mean, as you have employees coming in and out of the company, they have to sign very stringent non-disclosure agreements, and even then, the more people that touch that formula or whatever it may be that's a trade secret, the more likely that it might get out. So, some certain companies decide to use trade secrets, others decide to take their 20 years and file the patent. I know we're running short on time, and I'm not even going to go over the trade dress, but essentially, all of your engineers, scientists here, like I said, I was not really excited to be a behind-the-desk engineer when I graduated from undergrad. And so I wanted to do something a little more, in my mind, interactive, and so became a patent attorney, went to law school. I would highly suggest or recommend you all as engineers and scientists, as you graduate from undergrad and you have that science or engineering degree, which makes you eligible to become a patent agent, to check into that. Patent attorneys, patent agents, it's a really good field. It allows you to use your science background, but also allows you to have a little different, just life than you might if you were an engineer. I know that Professor DeBoer, he has is it a patent law course? Patent law course that he conducts here at the university, and I would highly suggest that if you have the opportunity to take it, it will go into much more detail than I went into today. And if at the end of when you graduate and have that degree, if you could go sit for the patent bar and get that designation of a patent agent, or if you choose to go to law school and become a patent attorney, it will benefit you greatly in your engineering career, even if you don't want to become a patent agent, because it shows most companies really, intellectual property is big. And so when they see that you may have an interest in becoming a patent agent or a patent attorney, they'll take great note at you as an engineer, one, but an employer, it might push you so that you get that job that you might not otherwise get. So I'd highly recommend, if you have the opportunity, to take the course on patent law here, and it might just be the path to your next career or whatever it might be. Thank you all for your time. If you have questions, I'm happy to answer any questions you might have.
We have time for one or two questions. Do we have a question from the audience?
There's an argument about who really invented the light bulb. Do you have any input on that, or is that?
No, I don't. I mean, there's all sorts of inventorship is a big deal across the board. So, the question is who invented this, who invented that. I don't look into that too much. But anybody else?
Do you have an opinion on how YouTube does their copyright stuff? Because I know there's a lot of controversy about that.
Yeah, I mean, I don't do a whole lot of copyright law because it's fairly it's not as important to me being an engineer and my clients who are engineering companies as the patents and trademarks. Stuff's copyrightable, and with the internet and cell phones and everything that we have these days, people are ripping off copyrighted items and throwing them up on YouTube and elsewhere. How a company like that is able to deal with that, I can't imagine. How do they know that this is, not yours, but this person's song or whatever it might be that's being put up on YouTube? But I don't envy them having to police that, because I'm sure it's very difficult.
If you have more questions, Mr. Parker will be here for a while, and you can join us for lunch in the Joyce Room. Let's give him another.